live.
Good afternoon and welcome to the Regulatory Transparency Project's virtual event. This is the second of two webinars discussing the Department of Government Efficiency, Opportunities and Challenges. This is part two. We're glad you're all here. My name is Marie Blanchard and I am the Assistant Director of the Federalist Society's Regulatory Transparency Project. We're pleased to have with us a stellar panel of experts. Our moderator today is Casey Maddox, Vice President of Legal Strategy at Stand Together, and our two speakers include Abhishek Kambli, who is the Deputy Attorney General at the Office of the Kansas Attorney General, as well as Ken Davis, Senior Attorney and former Deputy Attorney General for the state of Virginia. As always, the opinions expressed are those of the experts, but please find more about our moderator, Casey, and our speakers, Abhi and Ken, at fedsoc.org. That is fedsoc.org. And in order to get right to the discussion, I'll hand it off to Casey, our moderator today. Thank you, Casey, for joining us.
Absolutely, and thank you, Marie, for kicking us off, and thank you to the Federalist Society for hosting. So, as everyone knows, President-elect Trump has announced that Elon Musk and Vivek Ramaswamy will lead a new Department of Government Efficiency, or DOGE. And in a Wall Street Journal op-ed this past November, they explained that they have what they view as a sweeping mandate to cut the overreaching contra-constitutional federal bureaucracy down to size and deliver a federal government that would make our founders proud. That is a big task. They also say that their first task is identifying executive actions that can be taken to rescind thousands of regulations that exceed the statutory authority of those agencies. In December, FedSoc, the Regulatory Transparency Project, hosted the first of these conversations on DOGE with Susan Dudley, moderating a conversation between Professors Nick Begley and Christopher Walker, part of a series of late season wins for the University of Michigan, having both of them on that panel. This is the second installment in a continuation of that conversation on the challenges and opportunities for DOGE and what we can expect over the next 18 months that DOGE is going to be in all of our lives. So Ken, on January 20th, we'll begin with you. On January 20th or thereabouts, I expect there will be a number of new executive orders that may be important to DOGE's effectiveness. What are some of the actions that you think President Trump should take that would put DOGE in the best position to succeed?
Thank you, Casey, and thanks to Marie and the rest of the Federalist Society for sponsoring this program and giving us an opportunity to talk this afternoon about this very important subject and the heroic undertaking that is DOGE. Now, Casey, you mentioned that I'll say the strategy or the description from Vivek and Elon are about the program is laid out in some detail in a November op-ed in the Wall Street Journal. It was actually published on the 21st of November. And in that description, they say they intend to focus on identifying regulations that have been issued by agencies, by federal agencies, that are beyond the statutory authority of the agency to undertake. And they say that the president will issue executive orders to pause enforcement while the White House then initiates regulatory proceedings to formally rescind those regulations that have been identified. So their focus is on rescission. And in fact, every time there's a change of administrations, rescissions of regulations issued in the previous administration or sometime earlier massive program of rescission cutting the scope and the number, and they say the cost of regulations dramatically, thousands they promise, as you noted. Now, one important part of the I'll say the discussion that the announcement of the DOGE initiative has triggered is a discussion, really a resumption of a discussion between political figures and commentators, some of whom want to focus on the elimination of regulations, and others who, at least in a relatively speaking, want to focus on improving regulation. The improving regulation camp, I'll refer to it, includes a lot of large corporations, heavily regulated large corporations whose business plans, capital investments, and their operations are to a great extent defined by existing regulations. And so they are, of course, always looking to, from their perspective, improve regulations, improve the efficiency, lower the cost, deal with some of the procedural hassles associated with regulations. But they are less enthusiastic sometimes about simply eliminating regulations. So as this discussion between elimination and improvement plays out, the president could, along with all of his late January, day 1, day 2 executive orders, consider a couple of executive orders that I think are entirely consistent with the DOGE initiative that would also focus on improvements to regulation that regulated entities have long sought, deal with problems that regulated entities have long wrestled with and complained about. Now, one common problem for regulated entities faced with a new rule, especially one that requires significant capital investment or significant moderation to existing corporate operations, is a problem that arises from the interplay and the tension between the time that it would take to challenge and litigate the new rule and the time it will take to comply with the rule. A lot of regulations have compliance schedules in them. And so a regulated party, at least of that type, is often faced with a choice between litigating and taking no steps to comply in the hopes of winning its challenge, or undertaking the litigation and at the same time beginning to take steps to comply. Because if it doesn't take compliance steps while it's litigating and it loses, then it might not be able to meet the compliance schedule in the rule that it has challenged, and it could be subject to additional fines and penalties and costs. So this dilemma really presents them with a choice between exercising their constitutional rights to challenge a new rule and possibly face additional problems if it loses, or forego its constitutional right. Even if it wins, if it has undertaken steps to comply, it could be stuck with a lot of wasted cost. And even if it wins as a legal matter, if it has undertaken those costs and those steps and those investments and those operating adjustments, then it may not, if you will, enjoy the fruits of its litigation victory. It may simply comply as a matter of sunk cost. So this is sort of regulation by fait accompli. And it's a problem, as I say, especially in those cases where the regulated entities, like the utility industry that I used to work in, are industries characterized by large capital investments and long timelines to change their operations and facilities. So what to do about that? What on earth could President Trump do to improve this this kind of catch-22 by executive order early in his administration? Well, there's a concept in commercial contracts and commercial litigation that might provide some inspiration here. And that's an agreement that parties undertake sometimes in a contract, to say that if there's a dispute about any particular terms of the contract, no compliance, no performance will be required until the dispute is fully litigated. And so if you take that basic concept and apply it to federal regulation, what the president could do is issue an executive order that directs agencies to define their compliance schedules in their finalized rules, define their compliance schedules not by calendar dates, but in terms of a length of time that would not begin to run until any challenges to the finalized rules are fully litigated on the merits. And this tolling would would eliminate this catch-22 problem that entities are often faced with now, and would allow them to, in fact, enjoy the constitutional protections that are theirs.
And do you mean that to mean that that would work for that would be the effectiveness of the rule, not just for challengers to the rule, in the sense that this won't be enforced against you if you challenge the rule, but basically this will create a time frame for the enforcement of the rule that would allow for challenges to occur.
Right. Every incumbent at the time of the finalization or the issuance of the final rule is now potentially caught in this catch-22, and they would all benefit from this this adjustment. I mean, it's an old principle. Chief Justice Marshall said that you really, I'll read, the very essence of civil liberty consists in the right of every individual to claim the protection of the laws, whenever he receives an injury. So no regulated entity should have to choose between exercising their constitutional rights to challenge a rule and be faced with lost costs or additional penalties because they exercise those rights. So that's one executive order that the president could issue, I think, that would, it's not inconsistent with anything else in DOGE. It's not inconsistent with eliminating regulations, but it would also address those in the universe of regulated entities who are most concerned about improving things and not simply eliminating them. There's another thing that the president could do, and it arises from the problem that the cost and complexity and uncertainty and delays and so much of what regulated entities understandably do not like about the current situation arises from the fact that regulatory requirements are often written to require compliance with some standard, that is, something in the environmental area, like when you think about mitigation and remediation, that the regulatory requirement is for the entity to come up with a plan, a mitigation, a remediation plan that is adequate. The compliance is expressed in terms of a standard: adequate, sufficient, protective. And unsurprisingly, this is the kind of thing that leads to years-long litigation as the regulated entity and interveners and people on the other side of the issues and the issuing regulation go up and down the court system, fighting over whether the latest iteration of a compliance plan is adequate or sufficient. And it's extremely time-consuming and extremely expensive and wasteful. Justice Scalia once said that the rule of law is a law of rules. Rules, not standards. Bright line, prescriptive, prohibition, prescriptive directions, bright line directives about which there can be much less dispute because there's less uncertainty. I think when someone's drawing the comparison between a rule and a standard, they often refer to a speed limit as an example, basic example of a rule. There's, of course, going to be issues, still going to be issues about the whether the limit in the rule is appropriate or not, but it would be much simpler and take a lot of uncertainty and back and forth out of the system if agencies issued their regulations defined in terms of rules and not standards. And the president could direct them to do as they exercise their expertise, subject area expertise, to come up with a final rule based on, in fact, rules and not standards. Those two, of course, there are all kinds of issues with any executive order. Opponents will claim that it's beyond the president's authority to issue such an order. And so I'm not suggesting that these hypothetical executive orders are like conflict-free, but I think they are the kind of thing that could address people in the universe of regulated entities who are concerned about improving things and not just eliminating things.
Well, thank you, Ken. That's I think that's a great beginning. Abby, I'm going to move shift a little bit to another issue that you have raised, and this is, well, and frankly that Elon and Vivek raised in the Wall Street Journal op-ed, that may be an important question for the effectiveness of DOGE going forward, and that's the Impoundment Control Act, which they have indicated in the Wall Street Journal that they hope to challenge the constitutionality of the Impoundment Control Act, as it may limit the ability of DOGE or the president to prevent the expenditure of funds that have been appropriated by Congress. Walk us through the act and what its implications are for DOGE.
Yeah, so thank you again for having me on to Federalist Society on this very important topic. So the big issue, or one of the ambitions of DOGE, is to cut government spending. And one of the simplest ways, theoretically, at least hypothetically, to do that is for the executive to not spend all the money that the legislative branch gives to them. And this is where the Impoundment Control Act comes into play. People might have heard the term during the first Trump impeachment. That was regarding whether munitions go to Ukraine or were delayed. Some were accusing the president of violating the Impoundment Control Act as a result. The background of that was back in the 1970s. President Nixon and Congress, they got into back and forth over many disputes over which statutes should pass and which shouldn't. And the ones that passed over President Nixon's objections, some of what they would do is refuse to spend the money that was given by Congress to actually execute those laws. And it was at that time in 1974 they passed what was called the Impoundment Control Act. So the big picture of that is the president or any member of the executive branch can't just unilaterally decide not to spend money. And the process is that if the president disagrees with some type of spending that Congress passed, he has to go to Congress and he gets a 45-day period or legislative period where Congress can, through legislation, decide whether or not to approve that rescission. And if they either don't act or decline, then he can't. Then he has to spend the money. And the other kicker for rescission, and there's a different process for deferral. It's a little too into the weeds for this, but for rescission, during that period where Congress is deliberating on what to do, the president's still required to spend the money during that period. So you can kind of see how that will present a pretty big roadblock right away. And the other piece to that is compliance with this is overseen by the Government Accountability Office's Comptroller General. And not only does that person, who's a congressional officer, have the ability to police the executive branch through this, but they also, through the statute, have statutory standing to bring a civil case if the president or any agency violates it. So it is definitely going to create a burden for any ideas DOGE may have about cutting government spending or not spending all the money that they're entitled. But as the op-ed was saying, there are a lot of legal challenges that are out there for the Impoundment Control Act, which have simply just never gotten to the court yet. So yeah, when we get to that, I'll definitely talk a little bit more about that.
Yeah, well, let's go ahead and kind of dig into that question. I mean, what do you think? What do you think of the arguments? I'll ask you to opine here on the constitutionality of the ICA, and what do you think a challenge that actually would get to the court? What's this going to look like? Who's going to be the challenger, and what would that challenge look like that you think would actually get to?
Okay. Yeah, sure. So backing up, big picture, when we go back to the Constitution and the powers that are enumerated to the president, there's obviously the vesting clause, which puts all executive power in the president, as well as the take care clause to make sure that the laws are faithfully executed. And a common analogy that you might hear come up is, in the realm of criminal enforcement, for instance, no one questions that the president doesn't has some discretion into how to enforce the criminal laws. He doesn't have to prosecute every single person that violates a congressionally passed statute. At the same time, there has been a tradition in the country that the president doesn't have to spend all the money that Congress allots him. And this was mentioned in one of the cases, Clinton v. City of New York, where the Supreme Court acknowledged that the president does have that traditional power. There's some that say that the power doesn't extend to how to spend the money that's appropriated by Congress. He can only veto a spending bill or something of that sort beforehand. And they cite two cases which they say have answered the question, but when you look at those cases, they really haven't. The first is the case of Train v. City of New York. This was a case that came out in 1972 that was prior to the Impoundment Control Act being passed, actually. And it was another dispute between Nixon and Congress where there was an EPA statute passed and President Nixon decided not to spend the money that was given. So the city of New York was going to be the recipients of some of these funds. and they sued in federal court. And the court only answered the question of whether that particular statute required the president to spend the money. It didn't have anything to do with separation of powers or the broader constitutional question of whether the executive can be required to spend money rather than return it to the treasury. And then another case that some say dealt with it somewhat is Clinton v. City of New York. That was the famous line item veto case which held that the mechanisms for the line item veto passed by Congress were unlawful, and the court held that in that case it was, but it never directly answered the question whether the president is required to spend money. And even that case acknowledged that there is a historical tradition of the president refusing um, uh, to spend funds that are given by Congress. So, the other aspects of the legal problems with the Control Act are the procedural ones. So, one, it gives a statutory uh, creation of this or authority to oversee this by a comptroller general. And the case of Bowser v. Sinar, it basically says that Congress can't vest a congressional officer with executive functions if the big picture is that it's an executive function in deciding whether or not to spend money that Congress gives, then having a comptroller general oversee that process would be an example of a congressional officer performing executive function, which would also present its own separation of powers issue. The other is a procedural one on standing. So in Rains v. Byrd, the Supreme Court highlighted again that just because Congress passes a statute saying you can sue doesn't relieve a litigant of having to provide Article 3 standing. So if a comptroller general were to sue, the fact that he's entitled to sue under statute alone doesn't get him there. There has to be some other injury to the comptroller general himself as the litigant. And it's a little difficult to see exactly how that injury would look. Now, in terms of how a legal challenge could go, hypothetically, it would be difficult to demonstrate for someone on the outside looking in to directly challenge just because it would be difficult to demonstrate an injury from something and that the comptroller general does or something that happens in the act. So I think the most likely scenario that you'll see is on the defensive side. So for instance, let's say in a hypothetical scenario, um, it wouldn't be DOGE, it would be more the agency that chooses not to spend the funds that are allotted. Say they decided during the congressional period of 45 days that they're not going to spend the money and the comptroller general institutes an enforcement action. That could obviously be a pretty straightforward way that it ends up in court. Another avenue is if one of these agencies declines to spend money and there's a recipient of the fund that's who's the money is supposed to go to, they would potentially have standing to sue, and that's what you saw in things like Train v. City of New York, as well as Clinton v. City of New York. So those would be the two primary ways you could see a legal challenge. But the main thing is the Supreme Court's never answered the underlying constitutional question, and there's never been a direct challenge to the Impoundment Control Act. So if a case were to be brought in some fashion, you could probably expect it to go to the Supreme Court to finally answer that question.
Well, this is very helpful. I think well, before I go any further, one thing I wanted to make sure that I should have said toward the top is that we do certainly want to take questions. So by all means, you'll see a Q&A function. If you can drop your questions in there, I will we'll ask a couple more questions, and then we would love to turn to yours. So feel free to drop your questions in the Q&A function if you have them. So far, we've talked about DOGE as I'm not even sure exactly how to describe this thing, but it is an executive-ish entity anyway. I'm not sure whether it's fair to even call it an agency or what exactly it is, but an executive branch entity. But how much of DOGE's mission is actually going to require Congress to be directly directly involved. And I'll kick that over to both of you. Ken first, maybe as a broad question. I'll also note my colleague James Valbo at Cause of Action and Americans for Prosperity Foundation wrote an op-ed for Real Clear back in December. It was DOGE must be methodical to be effective. It's the title of it. I can drop it in the chat and we'll tweet it out in a bit as well. But basically, his argument is what should be happening is that the president should ask the agencies to begin assessing what rules that you have issued are beyond your statutory authority, especially sort of taking into account the court's decisions in some of the recent cases, Loper Bright and others. So take a fresh look at your statutory authority in the actual text of the statutes. What rules are beyond your authority? Send those over to Congress and let Congress decide, well, we do want this rule, and so we're going to make it a rule, or to actually sort of codify the rule, or we in fact don't want this rule, and so we will vote, or we'll if we don't want the rule, then the agencies can begin the rescission process on those rules. There's more there to James's point, but that's basically the general idea is that the agencies themselves, obviously probably with DOGE helping to facilitate that process, would be looking at what is your statutory authority and what have you done that's outside your statutory authority, with a fresh set of glasses on, and then asking Congress to participate in that process. What do you want out of this stuff? And it's your job to actually do these things if you want them. So we'll begin there. Both on the broader question about Congress's authority, feel free to weigh in on that point from James Valbo as well.
Well, I'll start by commenting on the op-ed that you just summarized. It's certainly appropriate and within the president's authority to direct agencies in the executive branch to review their existing regulations and their practices and anything else about their operations in light of recently issued Supreme Court cases that may raise issues about things that the agencies are doing and have on the books and their practices and their existing regulations. That's entirely appropriate. It's a good idea. Now, the subsequent steps in that suggested process, though, may become problematic. I know we have political appointments each time there's a new administration, political appointees that are formally responsible for the direction and administration of a regulatory agencies. But as we've seen over the years, and certainly during the first administration of President Trump, the permanent bureaucracy, everyone below the most recent political appointments sometimes can be very resistant of presidential directives, drag their feet, not respond, slow walk, et cetera, or leak and take the position that they've done nothing wrong. It's all within their statutory authority. So perhaps the first part of that approach could be, I'll say, beefed up some if the directive was to review existing regulations in light of the Loper decision, and until that review is completed in consultation with OMB and the White House, suspend any additional rulemaking on new rules. because we want to make sure that what you have done is constitutional, lawful. So don't add additional measures to the books until we're sure, all of us together, including the White House and OMB, that and the Justice Department, that everything is as it should be. I mean, this reminds me a little of the whole issue about retrospective benefit cost analysis to be conducted by agencies periodically to confirm that the benefit cost analysis that they conducted to justify the rule in the first place is in fact accurate, or it holds up under retrospective review. Everybody's been for that in principle, just like you'd be for compliance with Loper-Bright and everything else that's the Constitution requires in principle. But the concept of retrospective analysis never got much traction, has never gotten much traction, because there's no, I'll say, teeth put behind the directive to the agencies to take that action. During the Obama administration, Executive Order 13563 contained a section on retrospective analysis, but no teeth, no real requirement. It directed agencies to consider, to come up with a plan, and to look into this consistent with resources available and the agency's basic regulatory priorities. So no teeth. So here it's important to try to provide some teeth to a directive for a Loper review, or if the White House wants to direct a retrospective benefit cost analysis review, to try to provide some teeth with it, by pairing it with a directive that they don't go forward adding new regulations until they've complied with these look back requirements.
Ken, your point there is, sorry about that. Your point is particularly well taken about the needing some teeth. I know that, for example, Majority Leader Scalise had sent a letter to agencies over the summer. Sorry, that was asking for agencies to begin this process of trying to assess what rules might be implicated by Loper-Bright. And of course, the response, as one might expect out of a Democratic administration, is not particularly robust to that request. Maybe that's enough of a change, just having President Trump. But in any event, I think it does indicate that, yeah, you need some teeth here to make those kinds of requests for review be serious. But Abhi, I'll let you jump in from there.
Yeah, so I think there's definitely ways to, or the safest way to get anything done rather than try to deal with the legal challenge to the Impoundment Act, is to work directly with Congress as a direct, avenue for what I was talking about. When we're talking about rescission, they could just have Congress ready to go with their rescission request and coordinate everything to make sure that those rescission requests are granted, and then you follow the Impoundment Act rather than challenge it. And then, of course, Congress has the authority to fund enforcement of any agency rules. So if there's agency rules going back that are no longer lawful under Loper-Bright, one avenue is for Congress to identify those and defund enforcement of them. So there are definitely avenues where DOGE can work directly with Congress. And given that there's now a congressional DOGE caucus, it seems like those pieces are starting to move as well.
Well, I think the since I have both of you here, and you both come from sort of AG world anyway as well, I think one of the other questions may be the role of AGs in this process. How are AGs going to be potentially working with DOGE or in this process? Does it look like challenging some of the rules that are identified? Is that obviously AGs have been and AG's offices have been taking a leading role in that fight over the years. But what do you think the role of, for either of you, what do you think the role of attorneys general and their offices is going to be in this process with DOGE over the next couple of years?
Well, I can start. The states, of course, have a continuing and fundamental interest in taking action, defending action, entering litigation, initiating litigation to protect the principles of federalism and their status as states and within the federal system. And we've seen over the last really couple of decades really vigorous activity on the part of state attorneys general to get involved in the federal debates and litigation about federal regulations, either initiating as a group of states direct challenges to in their own litigation or intervening in litigation that otherwise has arisen at the institution of other parties. I think we all realize, and even Ramaswamy and Musk have acknowledged, that as the rescission process unfolds, there is going to be, as there was during the first Trump administration, a lot of pushback and a lot of litigation, a lot of suits filed by people defending the existing regulation and challenging the legality of the proposed rescission. And so I think the states will have a lot of opportunities to, I'll say, jump into the rescission process because the federal regulations at question, they deal with different subjects, and some particular subjects are of interest to some states and less to other states, but all states have an interest in their status as foundational entities in a federal system, and so they all have an interest in joining the challenge and upholding the rescission of regulations that are that undermine the federal system and have the federal government overreaching at the expense of the states. So I think, yeah, it'll be active.
Yeah, and I'll just add one thing is there's obviously, when I last checked, there's probably over 100 state AG lawsuits against the current administration. There's going to have to be some mechanism for all of those to be unwound. So states will obviously be involved in the ones that they've already sued on to get those to whatever resolution is that it looks like. In addition, there are opportunities for states to potentially intervene if it's within our state's interests on any legal challenges that arise while different regulations are being rescinded or other ones are being added. And then when you look at the historical regulation, there is an opportunity. So Loper Bright gets a lot of the attention, but I think probably the bigger case is Corner Post, which expands when the statute of limitations is available to sue on an APA rule. And if it's one of those older rules where the injury just happened or just discovered, then that reopens the statute of limitations from 6 years to that point. So it's more clear in the corporate side how that would make sense. For example, if a new corporation opens up and now they're subject to this older rule, obviously they couldn't have been injured before they existed. So there's avenues for states and other entities to also look at some of these old regulations, and Corner Post provides a mechanism to potentially reattack those.
Well, I promised we'd get to questions. We're going to go ahead and turn over to questions here. We just have a couple in the chat, but we'll begin with questions. And by all means, feel free to add questions here as well. If we don't, I have some other points we can get to. But apologies if I mistake the name. Manali Derekshani has a question. Suppose that Congress passes a spending bill that is provably and unambiguously unconstitutional. From a proper understanding of the constitutional text, how is the president legally or constitutionally obligated to follow through on the spending provisions of that bill? So I think this basically goes to the question Abby was raising earlier about the Impoundment Control Act in part, right? You have the related question of when is the administration required to enforce a law or to defend a law for that matter. And then this is the question, okay, well, if you're not required to enforce an unconstitutional law, why would you be required to follow through on the spending provisions under that law? So, Abhi, I'll let you answer.
Well, the answer to that is there's another statute whose constitutionality might be a question that prevents the executive branch from doing that, which is what we discussed with the Impoundment Control Act. And obviously, one thing they can do is work with Congress and see if a resolution can be reached on rescission. The other is one hypothetical scenario is just to let a legal challenge happen and let the court decide on the constitutionality of the Impoundment Control Act, as well as potentially the underlying provision. But another avenue, if there is something that Congress passed that is unconstitutional and some other party is injured by that, then that other party obviously has the ability to sue on that statute as well. So one of the things that we've seen kind of in this age that we live in, where it's lawmaking by pen and phone, is that you don't really see congressional statutes challenged as much. It's primarily agency rules. But if congressional action is unconstitutional, that's also able to be challenged. So a private litigant can also challenge an unconstitutional congressional spending bill if they are injured by it.
Right. Or for that matter, intervene to help defend.
Yeah.
Right. Whether they are wanted to help defend or not. Interveners, I think, I expect will probably be an important part of any challenge on the Impoundment Control Act. But Ken, did you have anything else to add on that point?
Well, I'll say expeditious litigation is the key step key thing, I think, for administration when it's faced with unconstitutional laws. Certainly not simply to enforce it, but not either simply to say, well, I'm not gonna enforce it. We've had over the last decade, a lot of officials, some at the federal level, some at the state level, including Virginia, from time to time issue personal statements, that is personal in their office, whether it's an attorney general or some other or an official in the executive branch saying, well, I don't think that such and such is constitutional. Therefore, I'm not going to defend it. I'm not going to enforce it. The path leads, that kind of conclusory political, I'll say posturing path, leads just to chaos. And it's irresponsible, and it's not consistent with the officials' sworn duty to uphold the Constitution, which includes the process in the Constitution to resolve issues about legality and constitutionality. So expeditious litigation.
Well, we have one other question, and I don't know if either one of you are going to have an answer to this, but I'll toss it out to you. But we have an anonymous person that asked if there are specific regulations that maybe that you can think of now that may be targeted, but kind of more broadly, are there types of rules or things like that you anticipate being in the sights of DOGE kind of through this process?
Yeah, so I think one thing right off the bat, anything that was upheld under step 2 of Chevron, that could be a pretty straightforward target. And I think Cato had already put out a list of different cases that could potentially be in that realm. So that's one, I think, very straightforward, um, easy target to have, because if it's upheld by law that's no longer good, then the agencies within full discretion to obviously get rid of that.
Yeah, I mean, you have rules also where in the rule itself, it flags the Chevron decision as part of the basis for the interpretation of the statute that allows for the rule, right? And so there are rules that exist like that in the Federal Register, and that would at least seem to sort of be a flag raising their hand and suggesting that it's at least something that ought to be considered. Is this a rule that would have been permissible without Chevron if the rulemaker thought that Chevron was actually important to the authority? So.
And yeah, the one other thing I forgot, like obviously the numerous Biden era rules are going to be on the cutting floor when the Trump administration comes in as well.
Ken, or anything else from you?
I'd like to come back just a moment to an earlier part of our conversation where we were talking about getting Congress involved in the identification of rules for rescission and so forth, getting Congress involved. In their Wall Street Journal op-ed that we've referred to a couple of times, Musk and Ramaswamy focus a great deal of attention on rescission and cost reduction and reduction in force and everything. But they also say at the beginning of the piece, where they note the fact that the current administrative form of government we have, with agencies making more, I'll say, laws than Congress making laws, is in fact contra-constitutional. It's not what the founders had in mind. And the op-ed concludes by saying, we're determined to carry out our sweeping mandate and deliver a federal government that would make the founders proud. Well, some of that's understandable and really admirable enthusiasm for the great task they have. But I think we should keep in mind that rescissions and cutbacks and elimination of regulations and consolidation of agencies and even the saving of a vast amount of money without more is not a kind of rebalancing of lawmaking activity and responsibility and authority, with the Congress taking action and enacting rules and the executive carrying them out and not enacting its standard-based regulations. This kind of rebalancing is not necessarily going to occur even if you have a drastic reduction in the number of regulations and the cost of them. It's like looking at a weed-filled vacant lot and you come in and mow them down and then leave, they will grow back. So unless and until, and this isn't inconsistent with DOGE. In fact, the heroic mandate and the discussion that they've prompted by the initiation of this project really sets the stage for a complementary discussion about the additional steps really to get our lawmaking, rule-making activity back in the first branch of government under Article 1, where it was intended by the founders to be.
Boy, that's this may be a great place to end the conversation, because I I very much agree. I think one of the things that I think will make DOGE a success. There are a lot of different things laid out in the op-ed, and we've heard from DOGE in terms of goals on just reducing spending or cutting regulation. But maybe the thing that would be the biggest success at the end of this couple of years of the DOGE era would be if we come out of it with a different understanding of how the Constitution sets up our government and how our government is supposed to work, where Congress is actually not only Congress itself is reinvigorated in doing its job, but the American people understand how the process is supposed to work. So I think that would be certainly a major shift, and perhaps the main thing that we can hope for from DOGE, not just a X percentage cut in federal spending, but a restoration of what we expect out of the way Congress is supposed to function. Well, thank you very much. Thanks to the Federalist Society for hosting us again, and Marie for kicking us off. Thanks to Ken and Abby for their comments. And Marie, we'll turn it back over to you.
Yes, thank you, Casey, and thanks Abby and Ken for sharing your points of view on DOGE. And thanks to you, the audience, for tuning into this program. If you want to find more content like this on the regulatory state and the American way of life, visit us at regproject.org, and we'll see you next time. Thank you, everyone.